Antitrust and consumer protection laws are fundamental to the smooth functioning of modern economies. These two pillars of economic regulation work in tandem to foster fair competition, encourage innovation, and safeguard the rights and interests of consumers. Understanding how they operate, why they matter, and how they are enforced is crucial for businesses, policymakers, and consumers alike. At the heart of antitrust regulation is the principle of competition. Markets thrive when businesses vie for customers by offering better products, lower prices, and innovative solutions. Without competition, a single company or a small group of firms could dominate the market, restrict choices, and inflate prices at the expense of everyone else. This is where antitrust laws come into play. The primary objective of antitrust laws is to prevent monopolies and anti-competitive practices. A monopoly, in its simplest form, is when one company becomes so dominant that it can control prices, stifle innovation, and block new entrants from competing. The consequences of unchecked monopolies can be severe. Consumers may pay more for less, innovation slows, and the overall health of the marketplace declines. Antitrust laws were created to stop this from happening. In the United States, the Sherman Antitrust Act of 1890 was the first major legislation aimed at curbing monopolistic behavior. This law made it illegal to restrain trade or attempt to monopolize a market. Over the years, it has served as the foundation for antitrust enforcement. The Clayton Act of 1914 built upon this by targeting specific practices, such as mergers that would substantially reduce competition and discriminatory pricing that could harm smaller competitors. That same year, the Federal Trade Commission Act established the Federal Trade Commission, or FTC, giving the government a dedicated agency to oversee and enforce both antitrust and consumer protection laws. Antitrust violations generally fall into several categories. Horizontal restraints involve agreements between direct competitors. Imagine two major airlines secretly agreeing to set a minimum price for flights between two cities. Such collusion undermines the competitive process and is strictly prohibited. Vertical restraints, on the other hand, occur along the supply chain. For example, a manufacturer might require retailers to sell its products at a fixed price, limiting the retailer's ability to compete on price. These arrangements can sometimes be legal, but are closely scrutinized for their impact on competition. Monopolization is another key concern. This happens when a company uses unfair or exclusionary tactics to dominate a market. A famous example is the case of Microsoft in the late 1990s. The company bundled its Internet Explorer browser with its Windows operating system, making it difficult for competitors to gain a foothold. The U.S. government argued that this practice was intended to squash competition, leading to a landmark antitrust case. Mergers and acquisitions also fall under the antitrust microscope. When two large companies in the same industry propose to merge, regulators assess whether the combined entity would have too much market power. If a merger would significantly reduce competition, it can be blocked. For instance, in 2015, the FTC intervened to stop the merger between Staples and Office Depot, two of the largest office supply retailers, on the grounds that it would harm competition and ultimately hurt consumers. While antitrust laws focus on the structure and behavior of markets, consumer protection laws are designed to ensure that individual buyers are treated fairly and honestly. These laws address a wide range of issues, from product safety and truthful advertising to privacy and financial transparency. The overarching purpose of consumer protection laws is to prevent harm, deception, and exploitation. Consumers should be able to trust that the products they buy are safe, that advertisements are honest, and that they have recourse if something goes wrong. For example, the Federal Trade Commission Act prohibits unfair or deceptive trade practices, giving the FTC the authority to act against companies that mislead or cheat consumers. Other important consumer protection laws include the Fair Credit Reporting Act, which ensures the accuracy and privacy of credit reports, and the Truth in Lending Act, which requires lenders to clearly disclose the terms and costs of credit. The Consumer Product Safety Act sets safety standards for everything from children's toys to household appliances, while the Children's Online Privacy Protection Act regulates how companies collect and use data from children online. Violations of consumer protection laws can take many forms. False advertising is a common issue. Imagine a company labeling its products as organic when they are not, or exaggerating the benefits of a health supplement. Hidden fees in loans or subscriptions are another problem, as are unsafe or defective products that put consumers at risk. In the digital age, misuse of consumer data and violations of privacy rights have become increasingly prominent concerns. Enforcing these laws is the responsibility of several agencies in the United States. The Federal Trade Commission plays a central role, investigating and prosecuting both antitrust and consumer protection violations. The Department of Justice's Antitrust Division focuses on criminal violations, such as price-fixing cartels, and reviews major mergers. The Consumer Financial Protection Bureau regulates financial products and services, ensuring that banks, credit card companies, and mortgage lenders treat customers fairly. State attorneys general also have the authority to enforce both antitrust and consumer protection laws within their jurisdictions, often working in coordination with federal agencies. There are many situations where antitrust and consumer protection laws overlap. Consider a scenario where a telecommunications company holds a monopoly in a region. If this company uses its dominant position to overcharge customers and misrepresent the quality of its services, both sets of laws might come into play. Antitrust authorities could investigate the company's market dominance and anti-competitive behavior, while consumer protection agencies could address the misleading advertising and unfair billing practices. Together, these laws provide a comprehensive framework for promoting fairness throughout the marketplace. The importance of these regulatory frameworks is not limited to the United States. Around the world, countries have developed their own versions of antitrust and consumer protection laws. In the European Union, the European Commission's Directorate General for Competition enforces competition law, investigating anti-competitive agreements, abuse of dominance, and reviewing mergers. In India, the Competition Commission of India plays a similar role, while the United Kingdom's Competition and Markets Authority oversees both competition and consumer protection issues. These global efforts reflect a shared understanding. Healthy competition and robust consumer protections are essential for economic growth, innovation, and public trust. When markets are open and fair, businesses are motivated to improve, and consumers benefit from better choices and lower prices. In today's interconnected world, these principles are more important than ever. As technology evolves and new business models emerge, regulators must stay vigilant. Digital platforms, for example, present unique challenges. Platforms can quickly achieve dominant positions, and the use of consumer data raises complex privacy issues. Regulators are adapting by updating laws, issuing new guidelines, and collaborating across borders to address cross-national challenges. For businesses, compliance with antitrust and consumer protection laws is not just a legal obligation, it's a competitive advantage. Companies that play by the rules earn the trust of their customers and partners, avoid costly legal battles, and contribute to a healthier marketplace. For consumers, these laws provide critical safeguards, ensuring that their rights are respected and that they can make informed choices. Ultimately, antitrust and consumer protection laws are about balance, balancing the interests of businesses and consumers, encouraging innovation while preventing abuse, and fostering markets that work for everyone. By understanding and supporting these pillars of economic regulation, we help build a marketplace that is fair, dynamic, and resilient, now and for the future.